community and professional organizations. And she's the past chair, the immediate past chair of the board of the San Antonio Lighthouse for the Blind. Didn't know that. We buy all of our office supplies from Lighthouse for the Blind. If you don't right now, you should. No, you didn't. Love supporting them. The prices are all commiserate with, anyway. Okay, sorry. She's, I lost my place. She's a great person. How's that? I'll just hand it over, and she's going to talk to us today about ethical considerations for our contacts with consumers.
Wonderful.
All right, thanks, Barbie.
All right, can everybody hear me? And all those in the ethosphere who are watching. Hopefully you can hear me as well. All right, so you've had a lot of information about capacity, how to determine it. I know you're a bit numb. I'm a bit numb. It's good. I'm going to give you some tools on how to take that information and move forward. And I do want to thank you for inviting me to speak today. So, moving forward, what would you do? And my favorite doctor, I was expecting you to be up front here to talk to us about your angst with that patient. A patient appears to be exhibiting signs of abuse. Oh, and I will say my disclaimer is I'm going to let you guys listen while I talk for a while, and then at the end we're going to switch roles, and I'm going to let you guys talk, and I'm going to listen. An elderly patient relates experiences that signal something is going on in the family, and your patient might be at risk. Your staff reports a client calling several times each day and not remembering the conversation. Those are fun. A gentleman makes frequent phone calls to 911 to request assistance with his oxygen tank and medication. Think about that for a second, because some of you have been in those roles. What do we need to think about? The safety and welfare of the individual, the mental capacity of the individual, the validity of the complaints. Are they making these up? Are they real? The financial strain on the family, the business, and or the community. You might be privy to all of this or only part of it, but those are things to think about. Is the person able to understand what you're saying? And I'm going to go into this a little later with the story, but you know, some of our seasoned members of our community don't want to have their hearing aids in. They don't hear you. And all of a sudden you put them in and turn on the volume, and darn it, they can hear everything that's going on, and you can have a great conversation. Amazingly, how one little small piece of technology can affect how you view one of your consumers, right? Can they communicate with you? Can they recognize familiar objects and individuals? Can they perform simple calculations? I have 2 boys. One had some we'll say math challenges when he was younger, and brought him home after a whole day of 2nd grade, could not figure out how to take 20 pockets and put them in 5 different groups. Didn't matter how to put them together, just however you wanted. So I brought him home, got some Skittles. I said, here's 20 Skittles, put them in 5 groups. I don't care how you do it. Turned to the 6-year-old, 5-year-old at the time. Here's 6 Skittles, just be quiet. The older brother trying so hard to make his little groups. The younger one, Mom, I just ate 1 Skittle, and if I eat 1 Skittle, I have 5 left, right? And I'm like, be quiet. Don't say a word. Sometimes it seems simple to one and not so simple to another. Can they reason logically? I have a 17, almost 18-year-old. There is no logic in my household right now. Administered daily life activities, bathing, grooming, dressing, walking, toileting. I'm still trying to get the 15-year-old to wash the dishes in the sink. What should you do? And I know you guys are all sitting there thinking, God, you know, I've had those types of situations. So traditionally, we're going to look at the level of capacity. You've heard, like I said, you've heard a lot of that today. You might be seeking a guardianship, and we do have some APS representatives here. If you have an abuse situation, you're going to call APS, but what we're looking at here may not necessarily rise to that level. So don't do the knee-jerk reaction to call them, because I know they got a lot on their plate already. And I know we've gone over this definition, but I say practice makes perfect, so we'll go do it again, because I know you've already had it several times. Are you dealing with an incapacitated person? I'm focusing on the middle part of this, but your minors are incapacitated. They are until they're 18. mine will always be incapacitated. But if you have an adult who, because of a physical or mental condition, is substantially unable to provide food, clothing, or shelter for himself or herself, care for the person's own physical health, or manage the person's own financial affairs, then we have a situation that we need to address. You might also have an incapacity where a guardian is appointed for receiving funds. But like I said, I'm focusing on that middle definition. Is the incapacity based on functional deficits in any of the following areas? I'm kind of being a little repetitive here, but I'm trying to bring it home for you. Handling business and managerial matters, managing financial affairs, operating a motor vehicle, making personal decisions regarding residence, voting, and marriage, and consenting to medical, dental, psychological, or psychiatric treatment. You've heard a lot about how these rights are very important that we are addressing, and we want to make sure what exactly the deficit is, and if there's a way to assist it, to have somebody else help with that part. We want to preserve as much independence as possible, because guardianship, and I think I just skipped a page and I apologize. Guardianship is a legal process where the probate judge, we had one sitting up here earlier, I think she might have left, determines that an individual, which we call a proposed ward, lacks capacity to care for him or herself. And we have another person who's appointed who's the guardian, and they're going to make all the decisions unless the judge says, I'm going to limit what your decision-making powers are. So how does this affect your rights? We can take away the right to vote, the right to drive, the right to marry, the right to travel, the right to decide where you're going to live. The judge has to consider the person's physical and mental limitations. And it really shouldn't be in a vacuum. We need to be looking at the broader picture, who's in their life, who's not in their life, who should not be in their life. The removal of decision-making authority should only be done as necessary to protect and promote the well-being of the incapacitated individual. And the judge must always consider the least restrictive means available to that person. I'm going to discuss a list, not an exhaustive list, but a list of least restricted later in my presentation. I think what's really important is we have constitutional rights, and as well, I can say as an officer of a court, because I am an attorney and we are considered officers of the court, it's our job to make sure that the law is followed. So each one of you has a constitutional right. It would not be appropriate for me to just say, Byron, you're looking kind of funny today. I think it's time to have a guardianship. That might be a little distressing to him. And if you think about it, as we age, and you've seen this so much in the elderly, especially those who have been significantly independent, they get to do whatever they want. And all of a sudden you're saying, I'm taking away your car keys. Or you're saying, no, you're not going to have the flexibility to go to that poker game once a week because I'm putting somebody else in charge of you, and maybe that person doesn't like you playing poker. All of a sudden, you're restricting them. And as Dr. Leatherman said earlier, it just brings them back to like a child stage. So think about how your children react to you when you're making decisions for them. I'm dealing with the teenagers, and I'm realizing that one's going to turn 18 in December, and he'll be an adult. And so I'm starting to let him make those decisions. But it's really hard to take that away. So what's next? Do we meet the criteria for incapacity? And if not, it might be time to write the information letter. It was discussed earlier as a referral to the probate court, and I'm going to give you some tools on how to do that. Before we get into that, I want to talk about some of the ways that the probate courts and our area agencies have been trying to address these referrals, because they are becoming quite voluminous. And as much as I think everybody loves the organizations that you guys work with, they're becoming greater and greater every year. And what we're finding is that there's high utilizers of 911. We call it the 911 meeting. We have the Center for Healthcare Services, Adult Protective Services, EMS, the Mobile Crisis Outreach. They meet with the probate courts once a month, and they review these high utilizers. And these are people without a support system. We assume there is no support system because we're getting a lot of calls. For example, maybe one person makes 25 calls in 4 months. You have people calling up saying, I need a sandwich for lunch. And some people think that's humorous, but think of the situation. Somebody's sitting by themselves, they physically cannot get up. Does that mean they need a guardianship? No. It may mean they don't have a support system. They need somebody to come in and make lunch, and maybe that's enough. Or make sure they get to the bathroom. Refilling an oxygen bottle. The scooter battery died. They need to switch that out. But it's putting a lot of pressure on our 911 system. Many of you may have seen the article in the Express News about a week ago. Chief Hood is putting together a mobile integrated health pilot program. It starts October 1. I'm very excited about it. And it's based on these meetings because they've had, their plan is to decrease 911 calls by about 3,000. That's a lot. And the EMS transports and the hospital admittance, EMS transports about 2,400. So you think about it. You think EMS is coming because there's an emergency, right? And that there's an immediate necessity to get to the hospital. An EMS transport because of the scooter battery? Not so much maybe an emergency. Oxygen maybe, but what if somebody had been there to help out? Okay? So what this unit's going to try and do is divert these individuals to get the care that they need so that we preserve more money for our system. They think they're going to save about $1.8 million a year. That's a lot of money. So what is an information letter? Essentially, it's an individual writing a letter to the probate court saying, I think this person needs some help. That's really what it is. It's a statute that we have. It's an 1102, used to be a 683. That's lost on you because we have a new code, but don't worry about the numbers. Just remember it's an information letter. And this helps those who are sitting in the doctor's office saying, I've got this patient here and I don't feel comfortable about this. It could be the social worker saying, something's not right here. It could be the hospital saying, you know, they seem okay, but there's nobody there to take care of them. We really could use that hospital bed. Where can we put that person? So what you do is you have this letter, and it provides biographical and residential information about the person, and we send it to the probate court. And an interested person can be anybody. It could be the person next door, it could be that social worker or that doctor. So here's where I give you your tools. This is specifically from the statute what you have to have in your information letter. And what I'm hearing from the probate courts and the people who look at these is we get a lot of calls, but they don't know how to do the information letter. So I'm hoping I'm going to educate you with what you need so that you can take out part of these steps. So you need the person's name, address, telephone number, county of residence, and date of birth. The type of residence that they're in at that time or that you have knowledge of. The relationship between the person and the person who's writing the letter. The names and telephone numbers of any known friends and relatives, whether a guardianship has been established. Sometimes you'll know that already, maybe you won't. And the existence of a power of attorney. We've talked about the powers of attorney before, and I agree with what's been said. Get it. Make sure you have it, because it can be your first line of defense. I always like to say that the declaration of guardian is your backup for that, because there's going to be conflicts, but at least while you had capacity, you've designated and told the court, this is who I want. The information letter shall also include the amount of income, if you know what it is, and the source of income. Describe any property that you might have knowledge of. And some of this you might not be privy to. You may just know, this guy's got 3 kids, I've got their names and phone numbers, I know there's a home address, and that's probably all I know. At least get that into the letter. Put as much as you can. The nature and degree of alleged incapacity. That you're probably going to have access to, or at least some portion of that. Whether the person is in imminent danger of serious impairment. And if the interested person is a family member, the letter must be signed and sworn to before a notary public. So my assumption is that if you're writing the information letter, you're not going to necessarily be a relative of this person, but if you are, you're going to swear to it. under penalty of perjury, that the information is true. Because I like to say that death and incapacity brings out the best in the family members, and sometimes they like to take advantage of these poor souls. And so we want to get them signing on the dotted line, saying that, yep, this is all true and correct, I'm not making it up. So the information letter gets to the courthouse. We have 2 statutory probate courts here in Bexar County, Probate Court 1 and Probate Court 2. In Probate Court 1, the information letter is going to go to Robert Augsburger. He's our court investigator. And in Probate Court number 2, Martin Collins is our staff attorney, and he does the review of the information letters there. Once it's been assigned to a court, these guys are going to call you up and kind of see if they can get a little more background information. Sometimes there's just a little bit in the paperwork, but maybe you have more information you didn't think was relevant. So they're going to ask you for that. Once the investigator does a little bit of background information, they're also going to, again, consider the least restrictive means. Sometimes they'll seek to locate family members or neighbors that might be able to assist. You'll be surprised who comes out of the woodwork sometimes. And sometimes we find that a person has to be fingerprinted and his identity might have to be determined because his name's Joe, that's all we know. And I'll get you a story on that in a minute. So if the information comes in and we feel the court investigator, either court, decides that we need to maybe consider a guardianship here. You've already been told a guardian ad litem gets appointed. A guardian ad litem is not an advocate. A guardian ad litem is an extension of the court to help the court make a decision. And it's literally defined as a person appointed by a court to represent the best interests of an incapacitated person in a guardianship proceeding. We have, in both of our courts, they're going to rely on a list of people that they know can handle this matter. They're not just going to hand it to any attorney. So we have a list of guardian ad litems that serve regularly. So the duties of a guardian ad litem. As I said, an officer of the court, not an advocate. An attorney ad litem, I'm not sure if that term has been used here, an attorney ad litem would serve as an advocate. And they're going to want to express the wishes of this proposed ward. But they also look at the best interests of the proposed ward, and they're going to specifically do their own bit of research. Review bank records, review medical records, and contact physicians, maybe considering getting an independent medical examination, interview and assess the proposed ward. Maybe a guardianship's needed, maybe not. Determine what the preference of the proposed ward is, but not necessarily hang their hat on that. That's just one of the bits of information they're going to have. And then if that guardianship is necessary, hopefully they can identify someone to serve as the guardian. If that's the case, they're going to prepare and file an application for guardianship. So, like I said, there's alternatives to guardianship. We always want to look at the least restrictive means. This is not the full list. I'm sure there is more out there, but I'm just going to briefly go over those. I think we're still good on time. My goal is to get you out to lunch early. Statutory durable power of attorney, you've known this as a financial power of attorney. Medical power of attorney. Directive to physicians, family, and surrogates. That directs the removal of life support. A surrogate decision maker. There are some, under the Health and Safety Code, Section 313, there are some surrogate decisions that can be made there, but primarily the courts, hospitals don't want to rely on that, and I don't blame them. You can have a representative payee. You've heard of that for Social Security. Veterans beneficiary fiduciary, volunteer management programs. Maybe a trust is helpful. Limited or joint bank accounts. Community administration. You may find that husband and wife, the husband is having dementia, might need a guardian of his person, but as far as the finances go, we can have the spouse set up in a community administrator position, and she can handle all of those assets and debt decisions so that we don't have to set up a guardian of the estate. Funds could be placed in the court registry, or we could have court-ordered mental health services. So, as I said before, we have some challenges because we're having a lot of referrals, and those are increasing annually, and we're not having enough guardians. The attorneys can handle part of it, but only so much. It's a big county. And then there's not always family members that we're finding to serve in the guardianship capacity. So what Judge Wolf was referring to earlier is it looks like we're finally going to get off the ground a guardianship program. We're very excited about it. What has been in place in Travis County and Harris County and Galveston County now looks like it's coming here. We have a supervisor and 2 case managers that have been identified. At the time that I prepared this presentation, they were finalizing the budget and the management of it, but I guess Judge Wolf said it's coming on board, so very excited about that. So let's let you guys do some talking. And I do have answers for all of these, but I just thought it'd be fun to hear what you guys had to say. Case study A, social worker at the hospital, working with a man in his late 30s who has alcohol-induced dementia. The hospital wants the man discharged. The man lacks capacity, and there are no powers of attorney in place. Man does have a father who is active in his care and a neighbor friend who also helps out. Anybody out there, what do you think? That's all you've been given. You're dumbfounded. I taught you nothing, no. So this was a case. A referral was made to the probate courts, and actually it was a social worker who called in, and the investigator said, here, I need you to put something in writing for me, even if it's an email, I need something. And appointed a guardian ad litem because they felt like something wasn't right here. The guardian ad litem spoke to the father, who was open to being a guardian, but couldn't afford to hire an attorney. And I find sometimes that's the barrier that we're having to address. Because actually what had happened is he had depleted so many assets of his own in caring for his son that he didn't have anything else to hire the attorney. So what the guardian ad litem did was helped the father get appointed as a guardian, helped the father apply for SSI and Medicaid for his son. And one of the organizations that assists, now the guardianship program may be taking care of this, we've had organizations like Catholic Charities who will help individuals seek a guardian when they don't have the funds to do so. Usually it's an uncontested guardianship, but it helps those people kind of move along in the process and not get stuck in the wheel. Okay, this one's actually mine. I had fun with this one. Divorce attorney has been working with his 74-year-old client. The client makes several phone calls in one day and does not remember any of the conversations with staff or that he has called previously. What should the attorney do? I'm sorry?
Medical evaluation.
Medical evaluation, okay. That would sound great, but a divorce attorney doesn't normally do that for his client. And so he's suggest, but he can't remember that they had that conversation. He called at 10 a.m., 12 noon, 2 p.m., 2:30, and 4. And he doesn't remember calling at all. Thank you. Exactly. But we did do that. Information letter was sent to the court. And it turns out, and he didn't have any powers of attorney, I was appointed as the guardian ad litem. What I found somewhat entertaining and somewhat sad was that he has 3 able-bodied children, one of which is actually living with him and helping him do everything he needs, but it never occurred to them to apply for guardianship. They just figured, well, this is what we've always been doing. It's going to be fine. But he was in the middle of a divorce from a second wife who'd been taking advantage of him and accessing funds and vehicles and things like that, and nobody knew what to do next. So we did apply, actually. We made sure that his doctor, which he has a new one now, that's one of my problems. Doctors that have worked with them for so long go, oh, they're fine. Don't worry about it. He looks the same as last time. Well, I really need a fresh perspective here. So they don't want to fill out the form. You saw the the examination form that the doctors traditionally complete and submit to the court. And I had submitted that to his doctor. I think I had to submit it like 3 times. And finally I got it, and I think the first one wasn't signed, and the second one, they said, oh, he has capacity. I'm thinking, I know he has capacity, and I'm not a rocket science. So what we ended up doing is the daughter who'd been handling all of the income and debts and bills and all that, she was appointed guardian of the estate, and the other daughter was appointed guardian of the person. And they're still continuing their team effort, and he's very happy. And I think they're hopefully almost done with the divorce. All right, case study C. A man at Haven for Hope is cold and complaining that he can't walk. He's admitted to the hospital, but the hospital is now trying to discharge him and discovers he has no identification. The administration's not even sure he is a United States citizen. He does have a picture. The man has periods of lucidity, but not otherwise maintaining capacity. Should the hospital deliver him back to Haven for Hope? Okay. What do you think the hospital should do? The social worker at the hospital now has this file on his or her desk going, oh, crap. What do we do? You know, they came close to that. What they did is they got an information letter sent to the court. So that's what I'm trying to teach you guys, information letters. And a guardian ad litem was appointed. And this guardian ad litem went to the immigration office with the picture. And I think part of it may have been some sort of ID, although I don't have that exact information, and they found a match. And then they filed for a resident alien card so that they could get Social Security to kick in. And this guardian ad litem requested a guardianship, contracted with a nursing home. And the hospital, so guardianship had not been set up yet, all right? What the hospital did is they said, all right, you haven't set up your guardianship, but we've got a guardian ad litem. Let us negotiate with the nursing home. We'll pay for 2 months of bed because that was cheaper than keeping him at the hospital. I love it when people come together and work on things. So what they did is they took care of that. The guardian ad litem actually ended up having to contact the congressman for the area because it was taking a long time to get the resident alien card, but it came through, and he's now in the nursing home and has Social Security. Yes, ma'am?
Who signed off on his move from the hospital?
I believe it was the guardian ad litem. The question was who signed off on the move, and I think it was the guardian ad litem. So that was an interesting way. To me, what I find so important is the left doesn't always talk to the right. And if we could just pick up the phone and call somebody, it's amazing what can be done. Calling a congressman to make sure a resident alien card comes through, maybe negotiating a little outside the box. We tend to be so restrictive in how we look at things, but if we can maybe reach over here a little bit, and if it's within the confines of the law, you might be able to create a benefit without creating more harm over here. All right, last one, and then you guys get a potty break. Doctor submits an information letter on his 94-year-old female patient at the request of the patient's granddaughter. Granddaughter's been taking care of grandma. Patient lives alone. She's very alert. She did loan some money to the Avon lady. Granddaughter suddenly moves money from the patient's account to her own account to safeguard funds from further distribution, because we don't want a lot of money going to the Avon lady. Call APS. What else? APS's ears are perked up. What else?
Send an information letter to the court.
Send an information letter. Okay, so let me give you some of the background on this one. The daughter, okay, so there's grandma, daughter, granddaughter, all right? The daughter had asked the doctor to send an information letter. The granddaughter and daughter did not get along. so you can understand some of the dynamics. Guardian ad litem was appointed and was looking at the least restrictive means. Do we really need a guardianship here? Because as Dr. Leatherman said before, just because they're 94 years old, just because it's age does not necessarily mean incapacity. There's some real sharp 94-year-olds that might not be able to physically handle things, but they know exactly what they're doing, and honestly, they know exactly why they gave the Avon lady that money, and we can all do that. So the guardian ad litem sought an independent examination of the 94-year-old because there was some question there about the doctor, and found some dementia, but not enough for a nursing home. It turns out this woman was only on 2 medications, anxiety medication and eye drops. Pretty impressive. What we found is that the granddaughter was trying to undermine the efforts to protect this woman, was not working with the guardian ad litem. So the guardian ad litem contacted a home care, so there's a nurse who's in there now once a week. The daughter has a power of attorney, and she's going to stick with that. But the daughter cannot exclude the granddaughter from visiting grandma. There's still that relationship there. As long as granddaughter's not putting her hand in the pot anymore, I think it's okay. Grandma wants to see granddaughter, so we want to maintain that relationship. The neighbors check on her every day. She has a great support network. One neighbor's even mowing the lawn. And this is the one I mentioned earlier about the hearing aids. The reason why the doctor originally wrote the information letter is the woman really wasn't listening to him and wasn't responding. She'd taken out her hearing aids. She didn't want to wear them. So that is your primer on information letters. Do you have any questions? Yes, ma'am. What the guardian ad litem is going to get is, she asked, how does HIPAA factor in? The guardian ad litem is going to be authorized to review all the medical information. We aren't passing that on to anybody in particular. We'll go meet with the doctor or review medical records there, or if it's at the nursing home, review medical records there. The only other place it's going would be to the court, because we have to report to the court with a recommendation. Anyone else?
But in that case, we would have, the patient would have to agree to allow us to send that information.
You're actually going to receive a court order. The appointment of the guardian ad litem directs anybody looking at it. But
what about the initial letter?
Oh, the information letter?
Right.
All it asks for is the nature and degree of incapacity, if you know it, because this is not necessarily going to be a doctor. My suggestion would be is if you felt that there was some level of incapacity, write as much as you can without giving a diagnosis. Once you're in with the probate court and talking to the court investigator, you would be able to share that, because the court is going to request it one way or the other.
Because I can't even release somebody's name. Can't release their name, can't release their address, age. All of those things are protected by HIPAA laws.
Do you have a social worker who works in your organization?
That would be me.
We have social workers call all the time. You can call. This is what
usually what I would do is refer to APS and let them do it, because I can't do that. I'm told you cannot release somebody's information.
That is a possible conflict. We've got 2 different statutes that are going at odds, and this person's going to suffer because of that.
Exactly.
I would, I'll tell you, without, the probate court's not going to release your name to any federal authorities saying that you violated HIPAA, because we're more concerned about making sure that person gets care. Yes?
I'm not sure exactly what the wording is as to the exceptions to confidentiality under HIPAA, but I would be very surprised if it does not address that situation.
Most likely. I don't have the statute in front of me, but I'd be happy to locate it. Yes, ma'am. Not at this time. The question was, APS has a special link that you can connect to if you need to make a referral there. She was asking if the probate court had that. It's certainly something I would consider if I get on the bench. How's that?
Amy?
I think that when you are considering the HIPAA restrictions, we all understand what those restrictions are, but this is sort of trying to balance between the ethical considerations of what we're responsible for our community. And so as Barbie said, the information letters are not released to anyone. The court is the only people who ever see the information letter and what they say and who they're from. So
actually, let me back that up. Not only is the court the only person or entity that sees it, they don't even get placed in a file. They don't go into a guardianship file. So it's as if it's an anonymous, it's not quite anonymous, but the letter stays with the court investigator. It does not, the only person that sees it is will see it as a guardian ad litem, but it does not get placed in the guardianship file. They've made sure that that stays just with the investigator, so they're not spreading that information further. So that at that point, the guardian ad litem, whatever information they can locate, in fact, we try and keep it as simple as possible. There's a lot of things that don't go into files these days. We want to protect the individual's privacy.
Well, and I have even a third layer to add on to that, which is I work for the federal government. So working for the VA, then that even handcuffs me even more than HIPAA, because then I have additional things on top of that. So although there's a lot of situations where I think it would be great if I could do this, I don't think I would be allowed to.
Well, you see, what I'm now standing here thinking is that maybe we need to get some congressmen and the two of us in a room and see what we can do.
Sounds good.
Yes, ma'am.
Okay.
Well, she said, can you inform law enforcement? But I think you have the same problem. What she was saying is, I don't feel comfortable releasing that name. But I think it's worth looking. I do think there probably are some exceptions to the HIPAA statute.
And I think she said she's found a way around it. If that's right, I don't want to speak for you, but you found a way around it that you report to APS, which you know under HIPAA you're allowed to. I would argue the same thing, that I'll bet under HIPAA it would not be excluded. But I can't promise you that, so.
Yeah, there is a way around it, but then you're also faced with the problem that sometimes your APS is not going to follow through quite like your guardian ad litem would.
I think APS wants to respond to that.
And I'm not being specific to any one person or to any APS worker, but I'm just saying they have limitations too.
Sure.
Hi, I'm with Adult Protective Services. I do want to say that if there's abuse, neglect, or exploitation, that is absolutely a HIPAA exemption. It's mandated. It's also included for attorneys and any other medical professionals. You do need to report abuse, neglect, or exploitation, but that's not the same thing as an information letter, and it is very rare, almost non-existent, that we would write that information letter. Just because we have other methods and we do have a relationship with Department of Aging and Disability Services for when our clients need a guardian, and there's no other resource possible.
I actually have this wonderful woman here who has technology's awesome. 45 CFR, section 164.512. There's a little known regulation buried in the HIPAA law that contains a safety valve. You can use this information, you can disclose it to avert a serious threat to health or safety. That sounds rather general to me, but that might work. It is. The code section is 45 CFR, section 164.512. Put it on a sticky, laminate it, hold that up to your boss. I'm covered. Okay? Oh, thank you, Mickey. Raise your hand. Good boy. All right. Anyone else? See, you're all excited and you need calories now. So if there are no other questions, thank you so much for the opportunity to speak to you.
Okay, thank you.
Valiente y te vi